Hey guys, welcome to Bilingual classes. This is Ganesh Pujari, and in my previous three videos, we have discussed administrative discretion, judiciary control and review over administrative discretion, and then we have discussed doctrine of proportionality. And this is the last video in this particular series, which is on doctrine of legitimate expectation. Before getting into any kind of legitimate expectation, let us try to understand what is fair expectation and legal expectation in my next slide. Before getting into legitimate expectation, let us try understand fair expectation and legal expectation. For example, imagine there is a boy who is getting always third rank in his class exams and the final exams are just 1 week away, and about 5,000 schools of that particular states, all the students are taking exams, and if his parents want him to get first rank among that 5,000 school, do you think is it a fair expectation? No, right? I agree the theory of nothing is impossible, but that is too short a time to prepare for such a big goal. Now the second, legal expectation. Imagine there was a theft happened at your home for about 10,000 rupees, and can you expect the court to give him death punishment for that particular offense? No, right? That is not quite legal. With that small little introduction, let us try understand what is all about legitimate expectation. Just like the doctrine of proportionality, the doctrine of legitimate expectation is also not part of any constitution or laws. It has developed over a period of time and first developed among English laws. Now, what is legitimate expectation? Now, the individuals are meeting public authority in many of the cases, and when they meet such authorities, they will have certain legitimate expectation in whatever transaction that they are doing. And these expectations are coming based on the past practice or maybe the promise given by the authorities. And as a result of a promise, representation, practice or policy made, adopted or announced by or on behalf of a government or a public authority need to be satisfied. Now, if they are not being satisfied, then such individual can approach the court, and court will see three important considerations while taking such cases. They are whether a legitimate expectation has arisen, if yes, whether it would be unlawful for the authority to frustrate such an expectation, and if it is found that the authority has done so, what remedies are available to the aggrieved person. So these are the three important key considerations will be done by court. Now, the few important case law, the first case law which came on this particular doctrine is Schmidt versus Secretary of State for Home Affairs. The second one was judicial review in public law, which is O'Reilly versus McCann. However, more clarity came through two important case laws, that is Council of Civil Services Unions versus Minister for the Civil Service and R versus North and East Devon Health Authority. These are the important aspects you need to mention while writing background and meaning for legitimate expectation. The next important question is when the doctrine of legitimate expectation can be applied. There are four important conditions. One, the representation must be very clear. Second one, it must be induced by the behavior of the public authority. And third one, it should be made by someone who had actual or apparent authority. Against them only it can be made. And fourth one, it must be applicable to the aggrieved parties. The one important aspect that you need to remember is the principle of natural justice is always a part of doctrine of legitimate expectation, where there is expectation by the public that the doctrine of bias or the fair hearing part is taken care. There are three important reasonableness points we need to observe while applying for doctrine of legitimate expectation. The first one is the representation may arise from either words or behavior of the parties. It may be in the form of words or with the behavior of the parties. Second one, the aggrieved party must not have utilized fraudulent measures to obtain the representation. There should not be any fraudulent measures which is used by the aggrieved party. That is one other condition, and must have disclosed all relevant information. The parties should disclose all the relevant information to the administrative authority. And the third one is the representation must usually be clear, unambiguous and devoid of all relevant qualification. These are the three important reasonableness that one need to follow before applying for doctrine of legitimate expectation. The first and very important case law for this doctrine is Schmidt versus Secretary of State. What happened during 1968, few students came to England to study the Scientology classes, And over a period of time, when they were studying in England, the Home Ministry felt that study of Scientology is not good for the society, and whoever is studying inside England need to go back to their particular country. And Home Ministry has given 2 months time to go back, but nobody has applied against this particular order. And when the day has come, they disagreed to go and ask for principle of natural justice, and the court held that there is nothing to be heard, so it was went in favor of the administrative authority. This is the first case law you can refer. I have given a lot of facts about this case law in this particular slide. Please take a screenshot and go through. When it comes to Indian context, I have two important case laws. The first one being State of Kerala versus KG Madhavan Pillai, which happened in the year 1988, and this is the first case as far as Indian context, which is for Doctrine of Legitimate Expectation. The facts of the cases are: sanction was issued for the respondent to open a new aided school and to upgrade the existing schools. However, an order was issued after 15 days to keep the previous sanction in abeyance. Order challenged considering violation of principle of natural justice. These were the facts. And what was held by Supreme Court? Supreme Court ruled that sanction has entitled the respondent with legitimate expectation. The order, however, has violated the principle of natural justice, so it went in favor of the school which has applied for this particular case. The second case is Food Corporation of India versus Kamadhenu Cattle Feed Industries, which happened in the year 1993. The fact of the case is the FCI of India called for tenders for sale of stock of damaged food grains, and a lot of people gave their bid, and the respondent bid was the highest. But after the bids, the Food Corporation of India called them all for negotiation again, and the respondent didn't attend because his bid was the highest. However, the negotiation process gone, and then respondent utilized the writ of mandamus and High Court accepted the same. Now later FCI gone to Supreme Court. Now Supreme Court said that yes, the respondent bid was the highest. However, it is inadequate considering the operation of the said commercial field. Non-acceptance of bid could not be faulted because it is common in that particular field. If all the bids are making loss, it can still open for negotiation. And it was the mistake of the respondent to not attend such negotiation, and the administrative authorities have tried to fulfill all the legitimate expectation by calling all the bidders to come for negotiation, including the respondent, and respondent just neglected it. It was his mistake, and court said that the decision of administrative authority was right. So the first case which went against the administrative authority, the case law is State of Kerala versus KG Madhavan Pillai, whereas the second case which went in favor of administrative authorities, which is Food Corporation of India versus Kamadhenu Cattle Feed Industries. If you want to refer any additional case laws, you can refer Navjot Corp Group Housing Society versus Union of India, Union of India versus Hindustan Development Corporation, MP Oil Extraction versus State of MP, National Buildings Construction Corporation versus S. Raghunathan, and Punjab Communication versus Union of India. All these are benchmarking or landmark cases, so you can refer them. That brings an end to the entire series of administrative discretion. What next? I'm not sure, maybe public corporations. I will see you in next class. All the very best for your exams. Please subscribe, like, share and comment my videos. And thank you so much for watching me.